Well, hello, everybody. Okay, so sis, can you hear me? Seeing if you guys can hear me. No audio. Better. Okay, because mine isn't showing. Okay, let me pop out and I'll pop right back in. Okay, how is that? Can you guys hear me now? Loud and clear? Okay, because it wasn't showing up on mine that that you guys could hear audio. Give some shout outs. I got some big news for you guys. Des, hello. Vera, hello. Looby Lou, Lisa, Jody McPhee. Git, hello from Sweden. Wow. Welcome. Shannon's Copper, Jody, Ellen, Tube Crime. Wonder if this guy and Barry Morphew would be good hunting buddies, right? Gray Lear, hello. Krista, Lisa, Oracle Blinn. Yes, happy Friday, everyone. Listening while at work. I can hear you fine. Okay, good. Hello, Alicia. Hello, everybody coming in. Krista, Vera, Oracle, Lisa, Krista, True Crime, Gray Lear, Get Ellen, Lou, Jody. I'm going to get a few of them up on here before we start. Hello, everybody coming in. Jody, Lisa, Vera. Okay, so hello, everybody coming in. Drop the dates. Okay, so you guys know we went over. Let me just share my screen here. Come up on screen. Why is it not? There it is. Okay, so we knew there's some new stuff. Hello, C. Susie, and welcome. New from New Hampshire, new to you. Well, welcome to the family. Marie, hello, my love. Okay, so the other day we went over Ann Taylor. She had to give notice of the alibi. She was ordered to give that by the 24th. So we're just going to go over this briefly. It's very short. This is notice of the defendant's response to the state's alibi demand, because the state said, okay, if you guys have got an alibi, we want to know about it. We're entitled to know about that. We want to know about it. We went over this. So, and then you guys, before we get started, you'll see this scrolling across the bottom. So any super chats in this live over $10, you are going to get an entry into, let me just see here. Now I put my light on. Let me just do this. Here is the set. Okay, so there's a necklace, there's a pendulum, and there is a crystal. And this is the Tiger's Eye set. So any super chat, super sticker over $10 in this, you will be counted and put on the wheel. The draw is Saturday morning at 11 a.m. Eastern. So that's why that is scrolling across the bottom. Okay, so back to this. So this is what Bryan Kohberger's lawyers put across. I'm going to go over it again just so we are refreshed. Okay. Love the set. Well, thank you. And there's also going to be either a purse, a deck of cards, maybe some other stuff. I got some solidite sticks. I don't know. I'm going to throw a bunch of other stuff in there with it too. So it's going to be a value of about $100. So you guys will get that. Good morning, Nana. And Marie, yes, I did get your super thanks. So I did add you to the wheel. Christine Babcock, I did get your PayPal. I added you to the wheel. You got 2 entries, Christine, because you gave a $20 donation. So you get 2 entries. Every $10 donation gets you gets an entry. Okay, so just to get that out of the way so people know that I did get that. I did see it. So they had, Bryan Kohberger had until the 24th to produce his alibi, where he was, if he has any witnesses to that, etc. Okay, let me just stop my other camera. So this is what they filed. We're just going to briefly go over this to get people up on speed. And then I'm going to show you where there's something that got leaked out that I don't think was supposed to be out, because I've never seen it in any of the documents. And we know that a lot of the documents have been sealed. And the prosecution comes back with a boom. Okay. So thank you, Sasadio. Comes now, Bryan C. Kohberger, by and through his attorney of record, Ann C. Taylor, public defender, and hereby files a notice in response to the demand for an alibi in compliance with Idaho Code 19-519 and Idaho Criminal Code 12.1. Mr. Kohberger notes that Idaho Code 19-519 subsection 4 preserves his constitutional right to silence as well as to testify in his own behalf. Now, we had a big thing about this in the last one. It's not up to Bryan Kohberger to prove anything. It's up to the prosecution. Yes. But as soon as Bryan Kohberger says he has an alibi, only that part now shifts to him to prove. That is something, in a case like this, in any criminal case, you don't have to prove anything. You don't even have to testify on your own behalf if you don't want to. It's totally up to the state. They have the burden to prove that you did this. Now, the only time some burden can shift is in a case like this, when you say, I have an alibi. Now the burden for that alibi shifts to you proving you have an alibi and producing it. Okay? I wanted to make that clear because there's a lot of people arguing with me on that the last time. So, he does have a constitutional right to remain silent. He has a constitutional right to remain silent. He doesn't have to say anything. He doesn't have to answer any questions. But there are certain things that come in when you're in a criminal case like this, where you say certain things like, I have an alibi. Now it shifts to you to produce that. That is part of disclosing what you have. The prosecution has to do it. The defense has to do it. So that's why prosecution said, judge, set a time limit. We want them to produce this. The trial's only 2 months away. We need this information. We don't want the last night rendezvous or a surprise of somebody being thrown up on the stand, right? So they had to give that information and they didn't. This is what they gave, what I'm reading you right now. So Mr. Kohberger stands firm on his constitutional right as well as the statutory recognition of that right. Noteworthy is that an alibi indicates a line of proof by which the defendant attempts to show that he could not have committed the crime of which he is accused because he was elsewhere at the time. Right. You have to prove it. These defense attorneys are grasping now at straws. There's also a second one that I'm going to go over. They want the case either dismissed or stayed. They want a preliminary hearing or something. What they are fighting now is the grand jury indictment. They're saying that a grand jury indictment has to be proved beyond a reasonable doubt. And that is not the case for a grand jury indictment. It doesn't stand to the same standards as an actual trial with jurors. So they're saying that the indictment should be thrown out because it doesn't prove beyond a reasonable doubt that he did it, which I believe they don't have to prove beyond a reasonable doubt. They have to get probable enough cause, probable enough evidence that this is the person that did that, and this is why we think he did it. It's up to a jury to decide if there is beyond a reasonable doubt. Nobody else, the jury. So as long as they produced enough evidence to the grand jury that the grand jury could make a decision that there's enough to more than not that he did it. Okay? So he has stated, okay, this is what we're going through right now, Lisa. We are going through this right now. So just give me a second. And another thing, if you have an alibi and the cops are at your door, they're going to arrest you for the deaths of a crime against which caused the death of 4 people. You're going to say, whoa, right there. You're not going to spend 7 months in jail and go through all this legal stuff and be locked up and everything else. You're going to come out with your alibi right away. So that's why I said it's hogwash. It's bollocks, as they say over in England. Bollocks. They're trying to raise some reasonable doubt somewhere. But when you say he has an alibi, and it says right here, noteworthy is that an alibi indicates a line of proof by which the defendant attempts to show that he could not have committed the crime of which he is accused because he was elsewhere at the time. Okay? So he stands firm, but he doesn't have to talk. Well, when you're ordered and it falls within disclosure, you have to produce that. You have to produce it. You can't just spring that on the prosecution in the court in the middle of a trial or just before the trial, the night before, whatever. You have to follow the same rules that you are wanting the prosecution to follow. Okay? C.C. Borkland alibi, defense 27 a.m., juror proof of facts, 2D 431, 2023. A defendant's denial of the charges against him does not constitute an alibi, but as soon as he offers evidence that he was at someplace other than where the crime of which he is charged was committed, he is raising the alibi defense. Okay, if he is saying that he was elsewhere, you gotta disclose it. You were ordered to disclose it by the 24th. You didn't do it. There's certain codes here. Okay, they're going by subsection 4 here, but there's a statute here that they have to follow when it comes to alibis. Just simply saying, like they say here, defendant's denial of the charges against him does not constitute an alibi. Right. But he came out and said he had an alibi. They had an alibi. So now that they said that, they have to produce that alibi. Okay. So Mr. Kohberger's defense team continues. Here we go. Okay. This is what they're counting on. Mr. Kohberger's defense team continues investigating and preparing this case. Evidence corroborating right here. Evidence corroborating Mr. Kohberger being at a location other than the King Road address will be disclosed pursuant to discovery and evidentiary rules as well as statutory requirements. Well, those are upon you. You were ordered by the court to produce them as discovery. Okay? It is anticipated this evidence may be offered by way of cross-examination of witnesses produced by the state, as well as calling expert witnesses. So what they're saying is they're going to try and use one of the prosecution's witness as an alibi that he was somewhere else, that they're going to be able to pull that out maybe under cross-examination, and that they will be calling an expert witness to back that up. Well, you got to name your expert witness and what they're being called for. You've got to put in what your alibi is. They're going around in circles and they are dissecting the statute. Please don't forget to give Willow love and appreciation by going, "Aw, thank you, Marie." Okay, so it's the same as they did before I show you the leaked, what I believe has been leaked. I don't think they wanted this to come out. This here is 23 pages Motion to dismiss the indictment on grounds of error in grand jury instructions or in the alternative remand for preliminary hearing. So they want the indictment dismissed. Now, I'm telling you, I spent 3 hours going through this. And I'm not going to go through this. I'm going to quickly skim this because this is what they're trying. You want to see how far the defense is reaching? Now, they are saying that the grand jury has to come to a beyond a reasonable doubt. No, they don't. They have to have the preponderance of the evidence would point towards him being guilty of the offense or of him committing this offense. That's all they need. The preponderance of the evidence. They always shed in the better light of what the prosecution, they lean more towards the prosecution than any defense stuff. That's what a grand jury does. They've been doing it for years. Now, let me just get to one of these. You guys are going to howl here. Failure to properly instruct a grand jury as a standard of proof is grounds for the dismissal of the indictment. The grand jury was erroneously instructed with the standard required for a presentment. Thus, the court should treat the indictment as a presentment. Different languages meaning the same thing, okay? With either the presentment or a charging document type thing. It's same wording, just different. They're it's like they can try and confuse the judge into saying, oh my gosh, you're right. This isn't going to fly. I don't think it will at all. Okay. So they are going back to this statute was in existence at the time of the Idaho Constitution was adopted. In 1887, 1864, when construing the Idaho Constitution, the primary object is to determine the intent of the framers. So they're citing, and all through this, okay, I'm going to tell you, they are citing going back to English law. How things were initially set regarding grand juries, going back to 1912, they are referencing cases from the 1800s, from the very early 1900s, into 2011, where they say laws adopted in 1851, copied for, if that were not enough, it is one of many laws that were adopted in 1863, 1864, copied verbatim from laws adopted in 1851 in the state of California, and then adopted in 1987. They're going back, they're citing cases from 81, 79, 19, look at this, 1969, 1862. They are really, they're going, this is like, I failed history. I'm telling you, you guys, no word of a lie. I failed history. This is what I didn't like in history. I don't really care about what happened in 1862 because times have changed. Look at this, 1826. They're citing cases that happened hundreds of years ago. How this came to be in 1936. This case was cited. 1980 cases are being cited. It's like that through this whole thing. Okay. To understand why the field code broke with the common law, like we're going right back to the BNA Act and all this bullshit. And in 1906, they're relating to practices that happened in 1906, hereafter called a grand jury. The political and legal standpoint of the law that was derived from something in 1906. It's like, this is crazy. Like, there's no way I would even attempt to make you guys sit through this crap. Okay. But they're going back to 1639, 1672, Massachusetts law, 1984, 1965. This is just bollocks. They're not going to win this. I think the grand jury is it's going to stick. Okay. So back to this. Let's get back to this. So this is what they filed as per the order of the judge to give the alibi. If you're saying he's somewhere else, give it up. And they're saying they don't have to do it. He has a right to remain silent. He does. But when you bring up something that is discoverable for the prosecution, you have to give it. Just like when the prosecution has something that could be exculpatory, ain't going to be good for the prosecution, they still have to give that to the defense. Even though it's going to be exculpatory, it's going to maybe hurt their case, they have to give that. It's in the discovery rules, in their Brady rules. So they were ordered and they didn't do it. This was their answer. Well, the prosecution has snapped back. Let me just go before we get there, because it's right here. I always felt like it's a defense standard to try and get the case dismissed for whatever before the case even started. Yes. But once they said they had an alibi, they have to produce that. Okay. So now they're going, oh crap. We didn't think this was going to happen. We thought what we said over here, that evidence is going to come out when we cross-examine one of your witnesses. And by calling one of our expert witnesses, they feel like they don't have to give their witness list until a little bit further down the line. So they'll do it at that time. And they'll give their alibi at that time. No, it doesn't fly. You can't mix the two. You can't. They were ordered to give up the alibi, the name and where he was supposed to be, that you guys are saying that he was not there. And that you offered evidence that you were going to offer evidence that he was some other place other than the King Road address when these crimes were committed. You got to give that, okay? Pretty much Shannon's copper. They don't have the burden to prove the same way they do in a trial. In a jury trial, you have to prove that he did it beyond a reasonable doubt. Beyond all reasonable doubt. Whereas a grand jury, the preponderance of the evidence that they submit with what they got against Bryan Kohberger has to be in the favor of, yes, more so, he did commit this than he didn't. That's all they have to do. That's why you don't get everything in the probable cause affidavit or the indictment, right? They don't have to put everything in there. So here we go. You guys ready? This is the motion to compel notice of defense of alibi, or alternatively to bar certain evidence. What does that mean? That means either, like, we want a motion to compel, which means ordering them to give the notice of defense of alibi. We want the person or persons names that are his alibi, where he was. If he was somewhere else other than King Road, where was that? They want that evidence, and they want it now solidly ordered. It was already ordered. And if they don't give it, then they don't want that alibi defense to be able to come in. Give me just 1 second. All right. So the state is now peeved off. Gotta go, Nana. Okay, Nana, you have a good day, hon. Love you. Tube crime. It is so funny that you mentioned that, because I went to school with Jim Carrey in Burlington. I personally didn't like him then, and I don't like him now, but yeah. I think you're right about the defense reaching. It's like Jim Carrey in Dumb and Dumber. So you're saying there's a chance. There ain't no chance. They got zilch. They got nothing. If he had a rock solid alibi, that would have already been produced, and they wouldn't be beating around the bush and trying to escape now, saying, well, we don't have an alibi. Okay? I don't think they have an alibi, period. I was not expecting ever to see an alibi come from the defense at all. So I wasn't surprised that they didn't produce it on the 24th, because they don't have one. If they did, he wouldn't be sitting in jail for the last 7 and a bit months, okay? And his whole life being put out there into the world to see what a nutbar he is. Okay, let's get into it, you guys. Comes now the state of Idaho. This is 5 pages. You're going to have to listen right to the end to see what slips. And I believe that this would have been under seal. Comes, because I haven't seen it in any of the documents, comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court for an order compelling the defense to comply in full with Idaho Code 19-519 ICR 12.1 and provide the state with notice of any alibi that may be offered herein, and said notice to include the specific place or places at which the defendant claims to have been at the time of the burglary and homicides in this case, and the names and addresses of all witnesses upon whom the defendant intends to rely to establish such alibi. That's including, let's go back over here, calling an expert witness. Okay? So they have to name their expert witness that they intend on calling. Anybody that they want to use in this. As the court file reflects, the state filed its request for disclosure, alibi demand on May 23rd, 2023, and served the defense on that same day. The parties subsequently stipulated to extend the statutory time for the defendant to provide the notice of alibi and comply with Idaho Code 19-519 ICR 12.1 to July 24th. Okay. On July 24th, the defendant filed a notice of defendant's response to the state's alibi demand. This document does not comply with the requirements of Idaho Code 19-519 in that it does not specify a place or places at which the defendant claims to have been at the time of the offenses herein. Hello, Butterfly Diana. Nor does it provide names and addresses of witnesses upon whom the defendant intends to rely. Which means these are people that are going to come to court and say, he wasn't there, he was with me at this place and this place, or that place and that place. The state recognizes that the defendant has a Sixth Amendment constitutional right to call witnesses in his or her defense. They're going to state a case, the state versus Juarez, Taylor versus Illinois. However, as noted in both of these cited cases, the defendant's right to call witnesses in his or her defense is not unfettered, and the state has a legitimate interest in obtaining timely and complete discovery response from the defendant. Okay? So what that means, if Bryan Kohberger was to give or have an alibi, the state is entitled to have that as soon as it's discoverable, which means as soon as somebody says there's an alibi, so they can look into that person or persons and look into those places or place, the video evidence, whatever, people that live there, reside there. Is there video footage? Is it a restaurant? Can they talk to the owner? Were these people here? So they can do their own little mini investigation on any people that he plans to call forward. Because anybody could say, like, my sister gets arrested and they say, call my sister in Canada. She knows I was talking to her for the whole 12 hours that, this car got stolen. It wasn't me. And they call me and it's like, oh, yeah, I was yes, she was. They're going to look into me. Okay, how did you communicate her? Over FaceTime, but there's no FaceTime between me and her at that time. You know what I mean? So they have a right to know all this, and they have a right to investigate, and this not be dropped on their lap at the last minute. Just the same as the defense is entitled to their discovery. Here we go. Bernice, I just went over this. The state has to prove their case. Yes. The defense has to prove zero. They don't even have to get on the stand and testify. When does that change? That changes when Bryan Kohberger says, I have an alibi. That's discoverable evidence. They have to turn that over to the prosecution. He has no right to keep that secret. There are certain laws and rules that have to be followed by both sides. You guys are all screaming, the prosecution hasn't given the defense, blah, 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 and they're entitled to that under Brady and under discovery. Well, guess what? The prosecution is entitled to discoverable evidence or alibi. And it is up to Bryan Kohberger to now give that alibi. Where were you? Who were you with? He brought it out. He is now under the gun to produce that alibi, and he has to produce it. And it is now discoverable, which means it has to be turned over to the prosecution. That's just like saying, well, we have this, but we're not telling you what it is. But we've got something that puts him there. But we're not going to tell you what it is. They have to tell them, which was the knife sheath with his DNA on it. They had to give it. Did they want to? Probably not. They want to surprise them with it. They have to. It's in the rules, and it works the same for both sides. You can't have it both ways, you guys. For all these ones that he's innocent and he's being treated unfairly, the rules work both ways. You can't have it one way. It's both ways. If this is something that's discoverable, the judge ordered it, and they didn't do it. They didn't do it. You know why? Because he doesn't have an alibi. The state doesn't have to prove that he has an alibi. It's up to Bryan Kohberger to prove he has an alibi. And if he had an alibi, he would have said it long ago and wouldn't be sitting in jail for 7 months. If he had an alibi. So stop it. Come on, think logically. Let's get back to this. They even extended time to him to produce it. So the defendant filed a notice of the defendant's response to the state's alibi. This document does not comply with the requirements. There you go. They have to follow the same requirements as the state has to follow. So if the state is required to turn over evidence of something, and then the defense brings up an alibi, they have to give up that evidence of alibi. Okay, so let's get back to this. The state recognizes that the defendant has a Sixth Amendment constitutional right to call witnesses in his or her defense. Yes, but they have to give the prosecution who those witnesses are going to be. They have to give them a list. However, as noted in both of these cited cases, the defendant's right to call witnesses in his or her defense is not unfettered, and the state has a legitimate interest in obtaining timely and complete discovery response from the defendant. They have that right under the same rules that they have to follow to give discovery to the defense. The defense has to follow those same rules. The Juarez court also observed, if requested by the state during discovery, a defendant intending to offer an alibi must file notice where the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses whose testimony will support the defendant's alibi. They have to give it. It's discoverable. As evidenced by the defendant's July 24, 2023 notice of the defense's response to state's alibi demand, the defendant has failed to comply in any fashion with the requirements of the statute, court rule, and applicable case law. They didn't follow the rules. When you bring up an alibi, you best be able to hand it over. Same as if the prosecution has somebody that's seen him go in there with a knife and come out, they have to hand over that information to the defense. If they have a witness that's seen him. Okay? Don't forget, we don't know all the evidence that is against Bryan Kohberger. Kevin Thompson seems to think he's not guilty too. We'll see. We'll see. It is important to note that the scheduled October 2nd trial, by the way, before we get to that, the August 2nd hearing has been vacated. So there's no hearing on August 2nd for Bryan Kohberger. It has been moved, I think, to the 18th. I'll put that in a note there on the community page. So it is important to note that the scheduled October 2nd, 2023 jury trial is barely more than 2 months away. Here it comes, you guys. If the defense intends to rely on alibi, it is essential that they be required to provide prompt notice so the state can fulfill its obligations under Idaho Code 19519, subsection 2, to investigate and respond to the notice of alibi. Any further delays will substantially prejudice the state's rights. Similar in the situation in Juarez, the state has no idea how the defendant's notice regarding alibi constitutes an alibi, and as observed above, the state is unable to comply with ICAR 12.1 in Idaho Code 19-519 because based on the lack of information in the case, we don't know how this is an alibi at all. And it's not. What they produced was not an alibi. The state also notes, as the United States Supreme Court observed in the Taylor versus Illinois, the ease with which an alibi can be fabricated and the state's interest in protecting itself against the 11th hour defense is both obvious and legitimate. Taylor Supra at 412 note 17, citing to Williams versus Florida. The adversary system of trial is hardly an end in itself. It is not yet a poker game, which players enjoy an absolute right to always conceal their cards until played. So, what they're saying there, things that are discoverable, things that fall under Brady have to be disclosed. The same as the prosecution has to give evidence that they come across that may not be in their favor, which they call exculpatory. They have to give it to the defense, whether it's going to hurt their case or not. They have to give it, even if it does hurt their case. Those are the rules. Those are the laws. And they fall the same with the alibi. Based on the above, the state respectfully, well, they're ordering it now, Monique. They want the information. They're entitled to it. They want it. Based on the above, the state respectfully prays the court for an order compelling the defendant to comply in full with Idaho Code 19-519 and ICR 12-.1. Those rules are specific. Specific. If you got an alibi, you got to follow these rules that everybody else has to follow. Bryan Kohberger is no different. He's no one special. He has to follow the same rules as the prosecution and any other defendant since these rules were invoked. By filing a notice specifying where the defendant claims to have been at the time of the alleged offenses and the names and addresses of the witnesses whose testimony will support the defendant's alibi. We've got a bunch in here that don't think he's guilty. Cool. Cool. Only time is going to tell. I never brought up OJ. You're bringing up OJ. Okay, you know what, AP? I never brought up OJ, and I have no problem, AJ, with you saying that you don't believe he's in it, you don't believe he's guilty, blah, 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 but you're not coming in here and telling anybody to shut up. Guess who's shutting up? Bye-bye. You're gone. You're gone. You're gone. Adios, amigos. And Monique, I respect that. I do respect that. So, I'm not blocking you. Like, you're saying your piece and you're saying it respectfully. Okay? I get it. There's a lot of people that don't think he's guilty. And as long as you talk respectfully, you are more than welcome. But when we get people like this one, so shut up about that. Nobody brought up OJ. Nobody. He brought up OJ. That's it. Gone. See you later. Bye bye. So Minik says, I need to see his side of the story in order for me to make a clear decision. Minik, I could not agree more with what you just said there. But in order for us to see his side of the story, he's got to give it. And when you say you have an alibi, there are rules. And this rule doesn't just apply, my dear, to Bryan Kohberger. This applies to anybody who says they have an alibi. Okay? So he has to give that information. So thank you for your comment, my dear, and thank you for staying respectable. Hello, Charissa Jane. The part's coming up that's going to be leaked, so I think, Kevin, I'm not going to hold that against Bryan Kohberger because I know that some people under stress, my sister being one of them, smiles at the most inappropriate times, and it's a coping mechanism for some. It shows nervousness for some. Like my brother at one point, somebody threw something in his tire and jammed his tire, and he went flying over the handlebars of his bike when they were young, and he messed up all his face, like cut it all up and everything. My sister was laughing. Not that she thought it was funny, but that was just her way of responding to certain things. So I'm not going to hold that against him. It could be just a coping mechanism. Hey, AJ. Hey there, Caroline. Hang on a sec, you guys. Okay, so here we are going to now get to where I feel the prosecution had no choice but to leak this little bit. Hello, Running Gray Wolf. So again, you guys, before we get to that, I will show you this again. Here, the camera's on. Let me do this. Here is what you see running across the bottom of the screen. Here is the tiger's eye set. This is a crystal, and there's a necklace, and there is a pendulum. It's hard to see. It's so dark here. We're under storm warnings again, but it's a beautiful, I can't get the light on it right. It's a beautiful, beautiful set. It is a real tiger's eye. There's going to be this, and there's going to be some other things. Maybe even one of the purses that I made is going to be thrown in for this draw also. So any super chat of $10 or more, you're automatically entered in, and your name is put on the wheel. I'm going to do it live. I'm going to pick the winner live on Saturday at 11 a.m. Eastern. I'll jump on here, and I will be going live with that draw. So if you do want it, get your super chats in. If you want to be on that list, we got quite a few on there right now. How many? We got 2, 3, 4, 5, 6, 7, 8, 9. We got 9 entries so far into it. I may throw in a deck of cards, some other crystals, some selenite, some other maybe keychains, stuff like that. There'll be a bunch of stuff that probably with a value of about $100, because this alone, the tiger's eye set, is valued at $60. So, okay, are you guys ready now? Okay, so we were at the point where the prosecution is asking the court for an order compelling the defendant to comply with the rules of Code 19519, which they said they had an alibi under, and ICR 12.1, by filing a notice specifying Can't talk today. Where the defendant claims to have been at the time of the alleged offenses, and the names and addresses of the witnesses whose testimony will support the defendant's alibi. Given some time constraints, the state prays that the court direct the defendant to comply no later than 10 days from the date of the court's order, and the state be allowed, pursuant to Idaho Code 19519, subsection 2. Here we go. You listening? So they want the defense to file names of the people, addresses where he was supposed to be, and what the prosecution is going to give to the defense. Sorry, you guys, I swallowed wrong. I took a sip of my drink here, and it's a mixture of berries, and I think some of the either skin from a berry or I don't know, some got stuck. Hang on. It's irritating my throat. So they want that, the names and the addresses of where he was apparently supposed to be. And they want that no later than 10 days from the date of the court's order. So they're pretty confident that they're going to get this order, and that the state be allowed pursuant. So they're asking the judge, please allow us, pursuant to Idaho Code 19519, subsection 2, to provide the defense written notice of names and addresses of witnesses who the state intends to rely on to establish the defendant's presence at the scene of the offenses. They have some kind, read that again. They want a court order because obviously this is under seal. The court, they also want an order to be able to provide the defense written notice of names and addresses of witnesses who the state intends to rely on to establish the defendant's presence at the scene of the offenses. They have people that are going to say he was there. Kevin Thompson, he doesn't have to prove he's innocent. But what he does have to prove is his alibi now, because he brought it forward. That now shifts the blame to him only for the alibi part, not for his innocence. You're right. He is innocent until proven guilty. But because he brought forth, I have an alibi, they now want it, which they are entitled to under discovery. We got a whole bunch coming in. He didn't do it. He didn't do it. He didn't do it. And if he had an alibi, Kevin, would you sit in jail for 7 months and have your whole life put out to the world? If you didn't do it and you had an alibi that proved you weren't there, would you sit in jail for 7 months? I don't think so. Yes, the state is entitled to the discovery, as the same as I hear all you guys, oh, the prosecution isn't giving up to the defense discovery. It works both ways. They have to give this to the prosecution. They were ordered by a judge to give the name and places that they are going to claim that he was. That is discoverable evidence. They brought it up. If they didn't want to give up an alibi, they should never have brought it up. They should have just sprung it on them in the middle of the trial and taken their chances. They didn't. They brought it up, which now means they have to produce that. They were given until July 24th to produce it. They turned around and said, oh, well, it's going to be one of your witnesses, and we're going to have an expert witness. Then you still have to give up that expert witness. You didn't. They didn't. They're not following the rules. So if you feel that Bryan Kohberger shouldn't have to follow the rules and produce an alibi, then I don't want to ever see your guys' names complaining if the defense doesn't give up what if the prosecution doesn't give up what the defense is entitled to. It works both ways. You can't have your cake and then eat it too. If you want the prosecution to follow the rules, then you got to follow the rules too. And the rule states, if the defendant says they have an alibi and they intend to bring it up in trial, they have to disclose that information to the prosecution. It cannot come as a surprise. They didn't want to do that. They never should have mentioned it. Now it is saying that because this stuff is under seal, we're not talking about that DNA right now, Kevin. We are talking about the alibi. And this is what they do. They come in there, well, this and that, and they try to distract off of the topic we're talking about. The topic we're talking about in this live is the alibi. We're not talking about the DNA. We're not talking about he was a delivery driver. That's all been debunked. Okay. We are talking about the alibi. He brought up the alibi. Now he has to produce it. No, the defense cannot violate Brady rules either, or discovery rules. And this is 100% discoverable because they said they had an alibi. Now they have to produce it. And now if they don't produce it, then they are never going to be able to use an alibi as a defense. If you're coming in here just to disrupt what we're doing, we're not talking about DNA or nothing. We're talking about the alibi. I don't want to have to start blocking people because I want you guys to be able to, if you don't believe he did it, that's fine. But right now we're talking about alibi. Don't distract with bringing up DNA and this and that and everything else. All the other things that are out there that have been debunked. Stop. Right. Okay, I'm going to say it one last time. Stop bringing up the DNA or I'm going to remove you. We are not talking about the DNA. Stop distracting this whole chat by bringing up DNA and everything else. That's not what we're talking about. We've already gone over that. If you want to argue about the DNA, go argue it somewhere else, not here. That's not what we are talking about in this chat. We are talking about this alibi. Okay, Minik, I'm sorry. You know what? I just said we are sticking on alibi. You're gone now. Sorry. I'm not putting up with it. This is my chat. This is my live. This is my channel. If you can't respect what we are doing here, then you are gone. Done. I may unblock you later, Minik, but right now I just asked. We're keeping this chat to topic. I'm not letting my chat go wild like other people do and then get into all this drama. We are talking about this alibi. That's what we're speaking about. You don't want to respect me and my wishes? Then you're gone. And I gave more than enough chances to Minik. And I'm sorry. I may unblock you, Minik, later because you did have some good comments there. But when I ask you to stop, I mean stop. I know you timed her out and then they continued, so that's why she's gone. I may unblock her. After the live, but she's not going to be unblocked right now. Kevin says, I want to hear his alibi too. So do I. The thing is, Kevin, what I have a problem with here, if you have an alibi, cops show up at your door, and I've said this over and over. We're coming here to arrest you of this brutal crime that happened to 4 college students They're all dead. We think you're the one that did it. If you were with somebody, you had an alibi, it would be absolutely not, officer. I was with Joe Blow. We were at Timbuktu restaurant and we were there from this time to this time. And then, you know, I'm on camera. We were drinking. Look at my apartment camera. You can see that I was there at the time of these murders. You can see me going in, my car never leaving there. That would be direct alibi evidence. They would not be able to hold him if he had that. If he had a solid alibi, he would have been released. But because he brought up alibi, he now has to give that as per the same rules that they want the prosecution to follow. They have to follow. They have to give it up. So, what are we finding out here? Well, I'm telling you, the first thing I would do, you say nothing, is saying to them, I have an alibi. Like, look I was with Joe Blow at this restaurant. That's not incriminating yourself. That's saying I was with Joe Blow at this restaurant. Remaining silent does not mean you're guilty. No, it doesn't. Can we stay on topic now here? What I'm getting at is this part right here. The prosecution is now asking the court to allow them to provide the defense written notice of names and addresses of witnesses who the state intends to rely on to establish the defendant's presence at the scene of the offenses, and any other witnesses to be relied on to rebut testimony of any of the defendant's alibi witnesses no less than 10 days before trial. So, they have witnesses that put him there. That's what this is just saying here. They have witnesses who the state intends to rely on to establish the defendant's presence at the scene of the offenses. They have witnesses that are going to put him there. Why isn't that in the charging document? The whatever name you want to call it. Why isn't it in there? Because they don't have to put everything in there. There could be more that they found out after he was arrested. Maybe once he was arrested, people felt comfortable coming forward. Maybe people came forward with, hey, look I didn't want to say it until he was arrested, but I have video cameras to come and take my footage. You don't know. Once a person like that, remember, 4 lives were already taken. So once people feel safe that that person that they think did it, and I'm not saying he's guilty, that they think did it is now locked up, they feel safe that they can come now forward with maybe some evidence. So what they are saying is that they are going to give to the defense written notice of names and addresses of witnesses who the state intends to rely on to establish the defendant's presence at the scene of the offenses. And they're going to give it to them within 10 days before trial, because they've come up with this alibi. So now by the time this gets back and the motion's heard again and it's ordered and they have to give it by a certain date, it's going to be like the trial's only a couple months away. So they're saying that at least 10 days before the trial, they will give them this information. The only problem I have with that is that you're not keeping an open mind. So you should never be a juror, ever. You got to go on the totality of the evidence presented at the trial. Am I confident he did it? Yeah. But I would never say I'm 100%. I'm very confident he did it. But I'll hear the evidence. That's right. You can have a difference of opinion, but don't come in here being rude and disrespectful because you're God. So mods, if somebody comes in here and they're being disrespectful, just get rid of them. That's it. Block them from the channel. They will no longer be able to chat. Like, I'm trying to give everybody a fair shake here. Adam Roberts says Kohberger's innocent. He's 100% sure. I don't know how you can be 100% sure when you don't have all the evidence yet. Kevin Thompson, they don't have to show it right now because the defense is the one that brought up alibi. The defense has to give them the alibi before they're going to respond to that. How can you respond to something you don't have yet? And as soon as they do get that from Kohberger, they will respond to it and give them that. But how can you respond to something you don't have yet? That's why the judge ordered them to give up the alibi by July 24th. They didn't do it. I don't think you know how it works. No, Kevin. The car that everybody says, oh, look at that, we got him on this other video camera, had a sunroof, number one. Bryan Kohberger's car did not have a sunroof. And it was a BMW or something like that lived in those apartments. That's not the same car that they've got on other video evidence doing a 3-point turn and everything else. Don't forget, the house that caught him on camera caught his car. And don't forget, there was no front license plate on Bryan Kohberger's car because he had Pennsylvania plates. Pennsylvania doesn't require front plates, but Washington State does. That car had Washington State plates on it on November 13th. Bryan Kohberger didn't get his Washington State plates until November 18th, well after the crime. Yeah, watch my blood pressure, all right. Well, I'm glad you have an open mind. Like, you can say right now from what you've heard, you think he's innocent. But to say that 100% he's innocent or 100% he's guilty, you can't say 100% until you hear all the evidence. Adam Roberts. They have his car with no front license plate. They got his GPS being, oh, never mind. They got, how unlucky can one guy get? Are you serious? How unlucky can one guy get? How unlucky? Unlucky that he gets up at that time of the morning, goes to the area at that time of the morning that this incident happened, that he's in the area, that he drives back and forth in front, parks behind, his DNA is found there. He has the exact same car that was seen speeding away and going in there that has no front license plate. How unlucky could one guy get that everything points to him? Then when they find his phone, he's got pictures of 2 of the victims on his phone. How unlucky could one person be in one night? I'm not willing right at this second to say he's 100% guilty. Not until I hear, do I believe he did it? I do. But can I say 100%? No, because I haven't heard all the evidence. Okay. Bye, Adam. Bye, Adam. You're coming here as a troll just to disrupt the chat. Goodbye. Yeah, with his luck, he shouldn't play the lotto. You know what I mean? Yeah, and he turns off his phone as he's going towards Moscow and then turns it back on just after the murders, after he speeds out and goes around and goes down that road where his phone starts pinging again by Genesee. Yeah. Why are you taking an hour route to go back home when you took the quickest route there, which is like 15 minutes to get there, but then you take the long way home at that time of the morning? And as somebody in his caliber, you're a teacher or instructor, you're a law, you got your PhD in law and you're teaching students and grading papers. Why are you up and running around at that time of the night, turning your phone on and off, and then your DNA just happens to be there on a knife sheath. Okay, I'm gonna do it on a knife sheath. Okay, on a knife sheath that you had bought. Okay, you had bought a K-bar knife and sheath just a couple months before, but your DNA is found on a sheath that was left at the crime scene under one of the bodies. Okay, let's not stop there. Want me to keep going? I'm going to keep going. Now, when they went and searched his apartment, his car, his office, his parents' home, everything, anywhere that Bryan Kohberger would keep any of his possessions, why didn't they find his K-bar knife and sheath? Where is it, Bryan? I'll wait. I'll wait. I know where the sheath is, and I have a good idea of where he disposed of the knife. We know where the sheath is. Where's the knife, Bryan? Where, if Bryan didn't do this, why didn't he produce his K-bar knife and sheath? Why? Because we know where the sheath was found, and we know he disposed of the knife. Obviously, the victim's DNA would be on that too, right? We don't know. It hasn't been disclosed yet. It's all under seal. Okay. And they're saying that they're going to give that at least 10 days before the trial. They're not going to wait to the last minute and hand it to them. So they got time to investigate their witnesses and that too. So the prosecution does have people that are going to put him there. Alternatively, the state prays for an order of this court pursuant to Idaho Code 519, subsection 4, prohibiting the defendant from presenting any evidence, whether by direct or cross-examination, in support of any claimed alibi other than from the defendant himself. Boom. You say you got an alibi, produce it. The court ordered you to produce it. You didn't produce it. You tried to say, oh, we're going to get it from your experts. No. Then give us what you think you're going to get. We're entitled to it, just like you're entitled to it from us. Shoulda, woulda, coulda. We're talking about the alibi. Yes, we are. But people keep going off on other tangents. If you think that I'm not going to back up what I say with receipts, I'm going to, because I'm tired of it. Mods, just start removing comments. If they're not masking their sensitive words, just remove their comments. Just, yeah. Like, these people are acting like children that can't follow the rules. Please stop messing with my vibe and being disruptive. Like, certain people now, I feel, are coming in and just blurting crap out just to be disruptive. So it's not going to happen. Stop it. Don't be that person. You want me to take you seriously? Like, even these people claiming certain stuff, they can't follow rules either. Simple rules. Simple rule. Be respectful. Don't curse and swear. Mask your words. Let's stay on topic. You can't follow simple instructions. Okay. Next. If there was an alibi, he would have already been out on bail, believe me. Okay, so it's the notice of the next hearing. Yes, it's August 18th at 10:30 in the morning. I'm going to write that down. BK, 10:30. So it'll be 12:30 my time. So the state's making a motion for a protective order. The state's motion to reconsider order staying for time for speedy trial. The state's motion scheduling order filed on July 17th. So, and the state's motion to compel notice of defense of alibi or alternatively to bar certain evidence filed on July 27th. So that's what the hearing is going to be about on the 18th. What else was it that I had here? Hang on. Oh, there's another one here too. I'll put this back up just so I can show my receipts. Okay. This was also filed. Order to file attachments to the defendant's motion to dismiss indictment on grounds of an error in the grand jury instructions or in the alternative remand for preliminary hearing under the seal. The court having before it the defendant's motion to file the attachments to the defendant's motion to dismiss indictment on the grounds of error in grand jury instructions or in the alternative remand for preliminary hearing under seal and good cause appearing now. Therefore, it is hereby ordered that the attachments to the defendant's motion to dismiss indictment on grounds of error in grand jury instructions or in the alternative remand for preliminary hearing shall be filed under seal pursuant to I-CAR 32, subsection I and subsection L. That was ordered July 26th. So, more things filed under seal. But their biggest thing is with the grand jury indictment, why they want it dismissed, is because they say that they didn't prove things beyond a reasonable doubt. Grand jury doesn't have to come to the conclusion that things were proved beyond a reasonable doubt. That is what a jury trial is for. What the grand jury has to find is the preponderance of the evidence that leans more towards that he did this than not. That's all. And all of the information doesn't have to be in or presented to the grand jury. All they have to do is give the grand jury enough to sign that indictment true bill. What's this one? Order to file the affidavit attached to the defendant's second motion to stay proceedings under seal. The court having before it defendant's motion to file the affidavit attached to the defendant's motion to stay proceedings under seal and good cause appearing now, therefore, it is hereby ordered that the affidavit attached to the defendant's second motion to stay proceedings shall be filed under seal. So again, we're not going to get any of that. What's this? Order providing and sealing jury panel selection list. Okay, I haven't read through this one. In response to a letter requested dated July 24th from Ann C. Taylor, public defender, the court is providing, pursuant to Rule 61.3 I-CAR, a copy of the Latah County Jury Panel Selection List from January 1st, 2023 to June 30th, 2023. The letter request and the jury panel selection list are attached to this order. The jury panel list shall not be duplicated or dispersed. We're not going to get it then. Violation of this order is contempt of court and subject to sanctions. The list should be sealed under Rule 32I, subsection I, and 2, subsection F, and 3, to protect the privacy of potential jurors. Did they attach it? If they did, you guys, I'm not going to show it. I just want to skim it. If I see one start of a name, I'm cutting it off. That's why I'm going so slow. No. Okay, good. Okay. So that's what has been filed. Boom, boom. End of story. So, as we've seen over here, this is what I think is slipped out a bit. This has been under seal. Because they need a hearing and a motion on this and an order from the judge, and then they're going to have 10 days from the date of the court's order. We're coming up the beginning of August. The trial is starting October 2nd. We've got 2 months. Time constraints are going to be touchy. So the prosecution is agreeing, because generally you have to give it within 30 days or 45 days or something like that before the trial is to start. So the prosecution is saying here, we'll give them the 10 days from the date of the order of the court to comply with this. And then we will make sure, because it's going to be a very tight schedule, because if they do give an alibi, the prosecution has a right to investigate that and investigate those people and where they said that they were with him, et cetera, et cetera. They're allowed to look into that. But they are going to make sure that they have their reply to any alibi if it is filed. They'll make sure that they give at least 10 days for the defense to go over their reply to their reply with alibi. If it's given, I don't think it's going to be given, because I think there's zilch. And the prosecution was very quick to state that things could be fabricated, that people can promise people things to say, say I was with you. I don't see how one person can be so unlucky to have so much circumstantial evidence putting him there and committing this crime. Like I said, I'm open. I'm going to listen to the trial. I'm going to cover it. It's going to be shown here every day. And we are going to see what the defense has. We're going to see what the prosecution has. We're going to see what kind of defense they have, what kind of evidence that they have that puts him somewhere else, if they have it. If they don't, it's not looking good for Bryan Kohberger. Ultimately, it's going to be up to those jurors. And we got to respect whatever they decide, even if it's not guilty. We got to respect that. And if he is found guilty, we got to respect that too. There's an automatic appeal, because the death penalty case is automatically going to be appealed anyway if he is found guilty. But we've got to prepare ourselves for this jury, when it's selected, may find him innocent, may say this isn't enough for us. We're going to have to respect that. Will the prosecution retry it again if that's the case? Absolutely. I think they will. I think they'll file an appeal too. But let's see what happens. For them to up the ante and not just go for the first degree on each victim, that they are now also seeking the death penalty, I think that they feel that they have more than enough. Now, like I said, this just come out, right? Now we know that the state wishes to be able to give this, so come out from under seal, to provide the defense written notice of names and addresses of witnesses who the state intends to rely on to establish the defendant's presence at the scene of the offenses. So they have something, that some kind of witness that puts him there, that has seen him there, that the state intends to rely on to establish the defendant's presence at the scene of the offenses. So, what do you guys think? Yeah, October 2nd is supposed to be his trial date. There is some hearings that are coming up. Let me just get it here. He was supposed to go for a motions hearing on August 2nd. That has been vacated. Oops. I put it wrong. BK on the 18th. Okay, so August 2nd, there was a motions hearing. August 11th has been also, I believe, moved to the 18th of August. So there's the next one, I believe, is August 18th. And then the jury trial starts October 2nd, you guys. Okay, why is this not? My chat here is not updating. Hang on. Okay, so I got to go over here. William Tardy says, I am of the opinion that the state doesn't have a solid case at this juncture. I beg to differ. I don't think they would have upped the ante from first degree to death penalty and seeking the death penalty on the first degrees if they didn't have enough to get that conviction. Because that raises, like, put it this way, say they didn't go for the death penalty. It's going to be life in prison. The guy's still alive. His life isn't going to be taken if they didn't go for the death penalty. By them now going for the death penalty, it raises that bar even higher to get a conviction. It raises the bar. They're making it harder on themselves by going for DP, for death penalty, because it raises the bar even higher than what it was already at. So for them to go for the death penalty, they feel they have a rock solid case. Now, don't forget, we don't know all the evidence, but what just came out here is they have a witness that puts him there at the scene of the offenses. William says, possibly, but William seems to think, I think they may have been trying to force a plea. I don't think so. Hang on. Let me exit here for a minute and come back in on StreamYard because my chat isn't working over here, so I can't put your comments up on screen. Give me a second, you guys. Okay, let me see. Okay, there we are. I don't know why my chat froze, but it did, so I had to go out and come back in. William says, possibly, I think they may have been trying to force a plea. I don't think so. I don't think they're going for a plea in this. These are 4 college students' lives that were taken. I don't think they're going to make any plea at all. Tattletales, hello and welcome. We're going to find out soon, Tattletale says. They can also choose to take it off the table. Yes, they can also, now that death penalty is on the table, they can choose to take it off the table if they want. I think they want him to plea out to avoid death, hence no trial. I think it's because they know that they've got him. But you could be right there, Tattletales and William. Yeah, I don't think that they would gamble either because they had a pretty, in my opinion only, they had, with what I've seen, they had a pretty strong case to get a conviction. Don't forget, they have a lot more that we don't know. But we don't know what the defense has. They say they have an alibi, then produce it. Once you've said it, the burden now falls to you to produce that. That's the only burden. I'm not saying this whole thing shifts now for the defense to prove innocence. No, that's not what I'm saying. What I'm saying is the only burden now that shifts to the defense is to produce that alibi. The prosecution is entitled to that discoverable evidence. They got to give it up. If they don't now, if the judge makes an order that they have to produce it and they don't, they can never use that in trial. They cannot use an alibi in trial if they don't produce their alibi. And I believe that the judge is going to order it. Just my opinion, you guys. Jacob, piss off. You're done. You're gone. 2 cents says, who verified the leaked info? It's right here in a court document. It's right here in a court document. That's where it came from. I don't know why my dang StreamYard is not, it's freezing up. So I can't put your comments on the screen, but Carolette says he would have had to plead guilty to take a plea. No, he's pled not guilty. Well, he actually didn't enter a plea at all. The judge entered a not guilty plea for him. At any time, if the prosecution offers him a deal and plead guilty, he can still do it, even though he's pled not guilty already. Well, he didn't plead. The judge entered that plea for him. Two cents says, too late for alibis anyway. No, it's not. It's never too late for an alibi. Tattletales, you're going to have to go back and listen to it then. I'm not going to go over all the documents again. If you scroll back, you will be able to see it. Yes, I'm going to be covering Lori Sutton's sentencing on Monday. I will have the thumbnail for it up once the live is done on Sunday. Or I might put it up on Saturday after the draw. So yes, I will be covering Lori Vallow's sentencing on Monday live. If the prosecution offers a deal to him, you plead guilty and we'll go for life in prison instead, and we'll take death penalty off the table. If he wants to take that plea so he spared his life, then yes, he would have to plead guilty. He would plead guilty to all the charges in return for taking the death penalty off the table. That could be, I'm not saying that's the plea that they would offer, but that's something that they could offer. I don't know what's going on with my StreamYards here. But my chat is not updating, and I don't know why. Hang on. Yeah, it's not updating for some reason. They added a whole bunch of new things to StreamYards, and ever since it's... William Tardy, if he pled guilty, there wouldn't be an option for appeal. If you plead guilty to something, you're pleading guilty to you did it. There's no appeal on that. Because William Tardy says, can't take a plea, it would severely limit any appeals. No, if you plead guilty, there is no appeals. You're pleading guilty, saying you did everything that they're accusing you of doing. There's no appealing that. Okay, so with that being said, you guys, I'm going to wrap this up, let you guys get back to what you were doing today. I just wanted to get this out. There's some stuff that I just came across these documents this morning. Like, I try to keep up as much as I can. He'll appeal in 10 years and get reduced sentence or set free. This case evidence and witnesses are too sketchy. 2 cents, how do you know that? You haven't even seen, nothing's been presented at trial yet. Two cents says, he'll appeal in 10 years and get reduced sentence or set free. This case's evidence and witnesses are too sketchy. How do you know? You haven't heard the evidence. You haven't heard any witnesses. Like, you're being ridiculous right now. You're being ridiculous, 2 cents. How do you know that the witnesses are sketchy when you haven't heard from the witnesses yet? That's sketchy to me. That comment you made is sketchy. No, and you can't file an appeal in 10 years and get a reduced sentence or set free. No, that's not the way it happens. You have a certain amount of time that you have to file an appeal on your case once you're found. If you're found guilty and you're sentenced, you have a set amount of time that you have to file your first appeal. The appeal process can go on for years and years and years and years and years, but you can't come not file an appeal and then 10 years down the line say, okay, now I want to file. It doesn't happen that way. Dozia do. I'm sorry people don't listen. Thank you, Dozia. It just gets annoying, Running Gray Wolf. He can't appeal after 10 years. No, there's a certain set time that he has to file his appeal in. Yeah, people that don't know nothing about the law are coming in on stuff that they and commenting on and oh gosh. I can see it if it was in question form, but when you're put he's going to appeal in 10 years and get a reduced set, you can't appeal in 10 years. You got to anyway. People just coming in trying to disrupt. Like, I don't have a problem with somebody coming in and saying, you know what, I don't think he did it, and this is why. There are some questions that need to be answered still. I agree. 2 cents and okay, well, I guess we'll have to wait and see, eh? But when you come in with just spewing rumor and theories that are being spewed on other channels and what about this theory and what about that and what about this and what about that and stuff, I heard this on Pinterest. There's a guy on Pinterest that said that he was partying and he knows he did. Like, I go by evidence. I go by what's put out by the courts and what is shown. I don't go by what other people are talking about or analyzing or, well, he couldn't have done this. He has Washington license plates. Duh, he does now. He didn't at the time of the offense. November 13th, he had Pennsylvania plates still on his car. He went and got Washington plates on the 18th. Why would he do that if he's going back to Pennsylvania? Because he probably realized, oh shit, my car doesn't have a front license plate. That is going to be one of the attributes that they can see on my car that points it to me, that that's my car, along with everything else they've got. Oh, God, here we go. We're going into Dylan's statement. Stop it. I'm not going into Dylan's statement. I'm talking about the alibi and everything. This is getting just way out of hand. I'm not doing it. I'm not going down rabbit holes and theories and things that people are putting out there just to disrupt informative, verifiable stuff like I do. I don't want it coming in here. Take your theories and stuff like that, take it to another channel. I don't do that here. I go by verified information. William Tardy, here we go. Serious question. $0.02. 2 cents. I'm too confrontational? Bye. You're an idiot. I said it. Yes, I said it. I own it. You're an idiot. Take your 2 cents somewhere else. I'm too confrontational. No, I'm confrontational because I'm bringing you facts and you don't like it. Don't discredit the person. Discredit the facts if you can. William Tardy, I am waiting for your serious question. Oh, gosh. I'm glad I don't drink. because I'd make myself a stiff drink right now and you think that I'm confrontational right now. Don't come in here and tell me what I'm showing you is not fact-based and that I'm too confrontational. You're too confrontational because you're trying to convince me and you're mad that you can't convince me to change my opinion to yours. I'm stating facts. Just because I'm talking, William, doesn't mean you can't post your question. Butterfly Dana. Renegade. Well, you know what? I'm going to exit StreamYard again and come back in, you guys. Stay here. I'm coming right back because I want to be able to put this guy's comment on screen. Okay. I seen the first few words and started shaking my head. Okay. Say this case was 6 male roommates and 4 were victims of the same crime. And one of the roommates gave the same statement as DM. Gave the exact same. 6 male roommates. Okay. 4 were victims of the same crime. Okay. And one of the roommates gave the same statement as DM. Okay. If everything was the exact same except for the gender, I would still be saying the same thing I am. Okay, I don't. Again, my StreamYard isn't updating. It's peeing me off. Okay, so again, William says they were at the house before, during, and after. Wouldn't you consider them a suspect? Say this case was 6 male roommates and 4 were victims of the same crime, and one of the roommates gave the same statement as DM. They were at the house before, during, and after. Wouldn't you consider them a suspect? No. I would initially interview them to find out what was going on. But what I get what you're trying to say, William. I posted the other part. You can only type so many words. Yes. So to answer your question, if any of them were, say, part of this, why wasn't the murder weapon found there? Why weren't they full of blood? There would be some evidence that one of them did it in that house. Then you may say, well, they waited so long to call the police. They could have gotten rid of anything. It would have been caught on the same cameras that caught Bryan, right? Look, I don't have a problem with theories, but you got to think logically. See, I knew that was coming. William says they also waited 8 hours to call the cops. You know, there was a lot of things, like I said, this was about the alibi today, so I'm not going to go in and fight this whole case in this session, but I'm telling you, the evidence points to a certain thing that happened in a certain time frame that happened. If the 2 roommates that survived are not under arrest, then they have good reason not to arrest them. If one of those roommates was involved in doing what they did, what was done, believe me, there would be some kind of evidence there 8 hours later. There would be some kind of tracking. There would be something on video that caught everything else. Sorry, you guys. This air conditioning blowing, it's like crazy. But anyway, they're not charged for a reason. And I'll wait to trial to find out. Don't forget, they were all drinking, probably doing some kind of illegal drugs. I'm not going to argue the whole case. Because you asked a question and now you're bringing in all kinds of other stuff that you want me to talk about now too. Waiting 8 hours. They called all kinds of people. You see how this opens up? See how people say, okay, just one question. Can you just answer this for me? What you think? I'm not saying I'm always right, but I'm saying I'll give you my honest opinion and what I think. But then it goes on and now it's blowing up into waiting 8 hours and all this other stuff. They called other people and leaving in jail. Oh, come on. Any other things about the alibi? I try to be logical. I mean, like I said, I've always said, Red and Grey Wolf, I worked in the criminal justice system for over 30 years in Canada. A lot of the things in Canada are the same as in the US, but as much as there's things that are the same, there's a lot that are different. I can't even take that comment off the screen for some reason. I don't know. No, I'm not saying you've been disrespectful, William, at all. I think you've been pretty respectful, actually. I'm just saying I don't want to get into all the different things of this case right now. All I wanted to do is come on and talk about this alibi thing that I found. And it seems to me that the prosecution has just slipped, that they do have witnesses that prove that he was there at the scene at the time of the occurrence. I mean, we could, it's almost 2:45 where I am. I'm in the East Coast. William, I could be here till midnight talking about this case. Penny Lou 1010. You had a comment? Let me scroll up and see if I can see it. Penny, I can't see it. Can you post it again, Penny, please? What I don't have patience for, you guys, is when trolls come in here and they start. I have no problem with somebody saying, you know what, I think he's innocent. Okay. But still keeping an open mind because we haven't heard all the evidence and we haven't heard what the defense has. So do I believe he did it? I do believe he did it. But can I say 100%? No. Not until I hear all the evidence and all the defense, what the defense has. What I have a problem with is people coming in here. He never bought that knife sheath. He never did this. He never did. How do you know that? How do you know that? And you come in and you want to argue a point with nothing to back it up. You're going on conjecture and rumor. I said, William would argue with a rock. No, I don't think he's arguing, Penny Lou. I don't think William's arguing at all. I think what he's asking are valid things that he's probably interested in knowing. I don't think he's been disrespectful at all. See, I think, William, and I get where you're coming from, and I respect where you're coming from for how you've come to that conclusion for yourself. But with somebody like myself, who's worked in criminal law for a lot of years, I maybe see a little bit more and can make out where things are going a little bit more than somebody who has no legal experience. And I'm not saying you don't have legal experience. I don't want you to take offense with that. But I'm seeing things that, like how I caught that. I haven't seen anybody else catch that yet. I think there probably will be one of the lawyers that have a YouTube channel. We don't mention them here, but maybe one of those lawyers are going to catch it. But a lot of people have gone over these documents and didn't catch that. So when you have worked in the legal system as long as I have, you pick up on things and you catch things that people that have no experience in law probably would overlook, so to speak. What I'm saying is, with the way and how aggressively the prosecution is going at this point, I personally feel that they have enough. There's a lot of things, like just with what I've caught slip out today, they have witnesses that put him there at the time of the offense. We didn't know that before. And there's going to be a lot of things like that that are going to come out that in trial that may sway your opinion. But right now, I respect you saying that with what you know as fact right now, so what the prosecution has put out or the defense has put out or the court documents, that you don't see it yet. I respect that. I give a lot of respect for that. But when somebody comes out and says, oh, well, it wasn't his knife sheath and this and that, I'm almost convinced it is. But is there still a little bit of doubt there? Right now, yes. It's dwindling away, because if the police are saying, okay, you bought a K-bar knife with the sheath 2 months before the murders, is what they're saying. Where's your K-bar? Produce it. Show us your knife. Because we found a sheath under one of the victims with your DNA on it. And the way people are thinking that DNA could have been transferred, his DNA transferred to that button, I don't think it holds water. Transfer DNA works in a lot of ways, but there's certain ways that it doesn't work. Carlotte says, I'd be horrible on a jury. Once I make up my mind, that's it. See, I would be honest, and I would be saying right now, if I was being questioned to be a potential juror, right now I'm at 90% he did it. I would be thrown off. They wouldn't keep me. And it's okay. If you think he's guilty, that's okay too. If you think he's not guilty, that's okay. We shouldn't make a final conclusion. I personally, 90% right now is saying, I think he's guilty. I will not say 100%. Carlotte says, in my opinion, guilty. I'm just not certain there wasn't a second person. Did the police say, if there was a second person, I also believe that he would have brought that out by now too. Did the police say that, or was it Dateline? I'm not, we don't bring other news sources or anything into the chat. Please don't mention other channels, other news sources. Penny Lou says, I like your knowledge. I wish people wouldn't challenge you and just listen. I mean, I don't mind being challenged, but be prepared for me to. And I was like this, even when I was dealing with courts and bail hearings and stuff like that, that I did do. It's like, you're going to come at me. And if I know what I've got is the truth, and I'm 100% sure of what I'm saying as fact, and I am, because I'm seeing it in the court documents. So I believe 100% they have a witness that puts them there. So if you want to challenge me on that, challenge me, but be prepared for me to come back with full force. If I didn't have evidence of it. Okay, what was deleted here? Oh, okay. But if I know something to be fact, I'm not going to sit back and go and be a little sheep and go, oh my God, somebody told me I wasn't right. So I'm just going to, okay, I'm not right. No, I don't do that. I didn't do it in my professional career, and I ain't going to do it here. The knife sheath is only part of the evidence. Absolutely. And no one's ever happy. We're not entitled to see everything right now. Okay, Running Gooey, Rolf, you take care, hon. Love you too. Marie Burke says they wouldn't want me as a juror. I'd have to go potty too much. Yes, I thank everybody for the contribution except for the trolls. Yeah, that's why, William, I go by what's in the documents and what has been presented so far. Marie Burks, excuse me, Judge, I have to go again. Exactly. Charissa, I wish I could put your comments up on screen. My StreamYard is acting up. Charissa says, that's the thing. If people want to say, I know he is innocent, explain how you know. Because by the looks of it, all signs point to him. Right. And like I'm saying, this guy would have to be the most unluckiest guy in the whole wide world to have everything pointing at this point to him. Oh no, I wouldn't even be. Carlot says, well, you'd be the flipping foreman. No, man, they wouldn't even let me on the jury. Yeah, a lot of this isn't going to be shared until trial. And so that's what I'm saying. I'm not going to say 100% right now he's going to be found guilty. I want to hear the trial first. I want to hear what evidence is there, what's not. That's when I will make my final. When the jury goes to deliberate, we're going to cover it all here. When that jury goes to deliberate, I'm going to tell you right then and there what I think the jury is going to come back with. But there's a few things, believe it or not, there are a few things that I'm having an issue with. So, with that being said, I'm going to wait to see how it's presented at trial to see if there's more to back that up that just wasn't in the affidavit. Yeah. Like I said, why are you going home? Why are you wearing gloves? Why are you disposing of your trash and the neighbors? Like there's just too much. You know what I mean? But I'm still keeping that window open because if there's something in there that I'm relying a lot on to say, I think he did it. If there's something there that debunks that, well, then I'm dropping back down. You know what I mean? Penny Lou, thank you for your super chat. I wish I could put it up on screen. I got to write you down here. Penny Lou 1010. Thank you for your $10. You will be put on the wheel for the draw. Everybody that gives a donation over $10, whether you want to or not, you're being put on the wheel. Reberks, I'd be like Arnold Korshak and Welcome Back Carter. Yeah, like why is he doing all this weird stuff? You know what I mean? Carolette says it's like teabag. There's a lot more than what we know. Yes. Like how many times did we go, oh my God? And we got a lot in this Stout case. William says, how long do you think it would take to commit this type of crime? Well, I'm not a professional in stuff like this, William, but I have seen some pretty angry people in my time and in my line of work. Do I think that this all could have been committed in a 15-minute period? Yep. And I'll tell you why. Because you've got somebody that, whether it be Bryan Kohberger or somebody else, I'm going to leave it like that. Whether it was Bryan Kohberger or somebody else that was in such a rage, somebody would have had to been in a rage and on one hell of a mission to do this. So whether it's Bryan or somebody else, that's one aspect. The second aspect you've got to take into consideration, all 4 victims, the other 2 were out partying and that too, but were already in their rooms, probably going to sleep. The 4 were still active, we're going to say, in the residence. It looks like it, and I'm saying it looks like because I have a different theory, but what is being shown right now, it looks like Kaylee and Maddie were about to go to sleep. I think something else happened in between that, but it's only my opinion, so I'm not going to go off on it here. You got to take into the fact that these 4 people were highly intoxicated, which lowers your ability to fight back. You're drowsy, you just want to sleep, maybe you want to puke your guts out. I just want to go to sleep. You're drunk. So you've got somebody who's apparently, possibly sober in a fit of a rage doing this to 4 people who are intoxicated. 3 of which were females. And if he had Ethan cornered in that back corner of the bedroom after he took Zaina's life and just swinging that knife around, like, how do you escape that? Right? I'm going to go by, even though there's a little bit of controversy there, I want to wait until I see the videos that caught him going in and back and forth and then finally up and around, and then speeding away. I want to see those videos before I say what I feel. Oh, reaction time, definitely. Almost like, it's like somebody's in the room. By the time you turn around and look up, already. Too late. You know what I mean? And you got somebody with a and then I feel he came down the stairs. I feel Zaina came out of the room, put the Jack in the Box bag in the kitchen, and was coming back to go to her room when he was coming down the stairs, and that's where he got her. I think he seen her right then and there, and it's like, oh God. And then when she fell just inside her doorway, that's when Ethan, he was made aware, oh God, now Ethan too. So he's got to take care of him too. Yeah. I'm not going down this incel. I'm just going to remove that because I'm not bringing this incel thing into it because it opens up a whole nother can of worms. Yeah, I'm no doctor either, but I know that you bleed a lot faster when you're drunk, when you've been drinking. It thins your blood. Alcohol thins your blood. It eats up all your electrolytes. That's what causes the hangover. So, I mean, being that they were intoxicated, drinking, you're more likely to bleed a lot quicker. So, and like if you're slashed on your arm, the first thing you're going to do is grab your hand and try and cover your arm, right? Which leaves you wide open to the next one that's coming at you. So that's how I think he got Ethan so easy. He may not have seen her. That door was just cracked. She said it was cracked open a little bit and she peeked out. He may not. Now after, oh my God, now I had to do these 2. I don't think they were part of the plan. I think when he's seen Zaina coming, I believe, back from the kitchen, and she turned around to see who was coming, she's seen him now. You know what I mean? I think they were collateral damage. I don't think he had any intentions on taking Zaina and Ethan. I think that was collateral damage. And once he had to do that, it's like he just wanted to get in and get out. And that slowed him down, having to do what he did with Ethan and Zaina. Now he's booking it for that back door. I don't think he was even looking towards that closed door. Or if it was even open at a crack, it would have been dark in her room. It was dark in the house. He probably did not see her. And her We don't know how intoxicated she was. We don't know if she was under some kind of other influence of something. She made, oh my God, why do all their friends fight and argue and yell and scream? Okay, at least he's leaving now. And go back to bed. I know when I was living in college dorm, well, it wasn't a dorm, but it was a college house, that so many times, like, there was screaming and fighting and yelling and crying going on. Boyfriends were breaking up with girlfriends getting caught with another guy in there, and the boyfriend walking in and catching her. There was so much of that that you just become to it. Like, oh, again, here we go. That's what I think happened with Dylan. William, I'm saying though, with that is, he felt that everybody was in their rooms. He was going up and getting them and hightailing it out of there. Nobody would have seen him. If they don't see him, then they're not witnesses, right? So if that door is closed, the bottom door is closed, they're not going to hear something back on the third floor because it's way in the back and it's not even above them or anything from the basement. They wouldn't have heard anything if they would have both been in the basement. They might have heard something in Zaina's room if somebody was in that room underneath her, but upstairs, the third floor on the other side, no. So it's like, I think he wanted, I still say Kaylee was the target. And I think he wanted to get Kaylee and get the hell out of there. That's what I think. But as he's coming down the stairs, I think he's seen Zaina, and I said this right from the get-go. From before he was even, half of this stuff coming out. And if you look back on my video that I did before they even announced that they were going to arrest somebody, I described Bryan Kohberger to a T. That read was done 2 weeks before they announced they had a suspect and they were going to arrest him. And I described him to a T, to even being somebody who gives lectures or something. If you haven't seen that, go under my live tab and go back to that read. It was in, I believe, November or December. And it says, I forget what it says on it. Anybody remember? Arrest is coming or something like that is the name of the video. If you want me to, William, I will get you the link for it. Just tell me in chat that you want the link for it and I'll put it in chat. I'll go and find it for you. Hi, Lori. Yeah. I don't think he even seen Dylan. By then, after, oh my God, now I had to get those two. He just wanted the hell out of there. Yeah, okay. Give me a second and I will get it for you. Where is it? Crap. Hang on a sec. I hate this new setup for us content creators. Okay, let me just go back here. I should put these all in a folder so they can be found easy. I'll have to get on that. Okay, here it is. Okay, I did this December 8th. This read was done December 8th. Let me get the link. Hang on. And just to show you guys. Okay, I just got to cover that up because it's a private read. Okay, let me go here. Okay, so the one I'm talking about is this one right here. And you can see it says Idaho 4 arrest is coming. And then over here you see I recorded that on December 8th. So I will grab the link for that and I will put it in chat. This is long before they even announced that they were going to have an arrest. So there it is there, December 8th. They arrested him on December 30th, I believe. They announced it the day before that they were making the arrest. Will the house be allowed in the court? I'm sorry, I couldn't remember what was said. I know the university owns it now. Now, the last I heard, Dossier was that they were emptying it out and they were going to demolish it, and they have held off. They said that they will hold off until October to demolish it. So they have given in a little bit. So they're going to hold off. So again, you guys, I'll give, let me just go over here and turn on my camera again so I can show you this. I'm going to give it 5 more minutes. If you guys do want to get a super chat, $10 super chat, you're entered into the draw to win this tiger eye set. There's a crystal. You can see, like in the light, they're really pretty. You can see they are true tiger eye. There's a crystal, a pendulum, and a necklace in this set. Also, I will be throwing in some other stuff, maybe a deck of cards, oracle cards, maybe some other stuff like either necklaces or bracelets or keychains or something. There'll be other stuff that comes in with it. It's about $100 value in total. $10 super chat. If you want to be entered into it, I will put you on the wheel. So for every $10, you get an entry. If you want, no pressure. I just wanted to make it available because I know a lot of people missed the last live with that. So the draw will be held Saturday morning at 11 a.m. and I will be doing that live. I will be entering everybody's name into the wheel live, and then we will spin the wheel live so you guys can see the draw happening. Also, the 2 people that won the draws last Sunday and the Sunday before, your stuff has been mailed out to you. On Sundays, I do mini reads. If you get a mini read, your name is put on the wheel. I spin the wheel at the end of the Sunday session, and somebody wins whatever is shown that day. It's different every week. Yeah, you can't wipe away what happened there. But I do believe that they're going to hold it until October. They may hold it even longer. Public opinion really, I think, changed their mind on demolishing it this month because they wanted it demolished in August before the semester started. So I do know that they said that they will not do it. They're going to revisit in October. Hopefully, if the jury does want to go through that house, because sometimes visuals mean everything. And it could go either way for the defense or the prosecution. So it may help the defense, it may help the prosecution. But I do believe that it should be preserved until after the trial. Well, they videotaped the whole house and everything and the scene, but it's not the same as actually being able to crack that door open and be able to see exactly what Dylan could see or what Bryan could have seen or other perpetrator, if it's not Bryan, could have seen, would he have been able to see her in there with the door cracked the way she said, etc.? So I hope it is kept, and I hope that they get a chance, if they so wish, to go in there. I mean, personally, I don't want to go in there. And then I know once it is no longer needed for the trial, I believe that it is going to be demolished and some kind of memorial put there in its place. So, okay, you guys, with that being said, I am going to let you guys get back to what you were doing. Thank you for being here. Thank you, mods, for being here and being on top of the trolls that come in. I appreciate you guys. They want to sweep it under the rug. Yeah. I appreciate you guys all being here. So there it is. I believe that that was an oops on the part of the prosecution. I don't think they could have said it any other way without having to have everything again under seal. But, you know, it's out there now. There's nothing they can do to change that. But now at least we know a little bit of some of the stuff that's been kept under seal. Okay, so with that being said, you guys, I'm going to let you go for now. Thank you for being here. I'm going to end it the way I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. Bye-bye for now.